And Hearings Officer Frank, can you hear me?
I can, yes.
Oh, can't hear him, but you sure can hear me.
Can you hear me? Can you hear me as well?
We can hear you now. Thank you.
Thank you.
And I believe we have everyone here, so we are ready to begin whenever you are.
Okay, if you want to start, I'm ready to go. Good morning. We will go on the record now. The time is just about 11 a.m. on September 11, 2025, and this is the time and the place for the hearing for Deschutes County file numbers 247 24-000346-LR and 247-25-000084-A. My name is Gregory Frank, and I am the hearings officer assigned to this matter. Before we turn to the particulars of the hearing, I would like to turn things back over to Planner Stewart, and where she will describe how the electronic process for this hearing will work. Ms. Stewart?
Good afternoon. For the record, my name is Audrey Stewart. I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is an appeal of a staff decision approving lot of record verification for the subject property. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. Then the testimony portion of the hearing will begin. The applicant will present first, followed by those in support, then those in opposition, and last, anyone neutral to the applicant's request will testify. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony, and finally, staff can make closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables here in the front of the room before beginning your testimony. For remote participants, if you wish to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. And if you're participating remotely, you can submit your written testimony via email at audrey.stewart@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing over to Hearings Officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we're following the normal hearing procedures under the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience as we make sure we get through each of the steps that have just been outlined. The application is being considered through what's called a quasi-judicial process, and I will consider only factual evidence that's in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. Standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing, and they are also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are also available directly from staff upon request. It is important that you direct all your testimony to the standards and the applicable criteria, and in this particular case, the appeal issues. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why that criteria or those criteria must apply, and to do so with specificity so that other participants may respond, and so that I can address that issue or those criteria and your arguments in the decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes, in other words, stops your ability to appeal that issue to the Land Use Board of Appeals. Also, failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. Now, I'd like to take just a couple minutes, if you can bear with me, because I'd like you to be aware of kind of what I know already, and so that you can address your testimony to what you think I know or what I've told you that I know. I want you to know that I've reviewed all the documents in the public record. I've reviewed the staff decision and the appeal statement carefully. The remainder of the documents in the record, I can say that I looked at them, but I cannot say that I studied them carefully. Do not assume that I understand or know anything about the contents of any documents. So if you wish to explain something to me in greater detail, or you think that I should know and it's important in this decision, then please feel that you can testify about that matter in your testimony. Based on my review of the appeal statement submitted in this case, I would like to make two comments. First, I am authorized to consider in land use appeals, which that is this kind of case, but I am required in those kind of cases to consider only the relevant criteria. And for those of you who do not deal in land use matters very often, when we say the word criteria, you can think the word law or rules. So I can only deal with the relevant laws or rules. As noted in my earlier comments, the staff in the staff decision set forth what the staff believes to be the relevant approval rules, criteria, laws. If you believe there are more or less or different criteria or rules that are relevant in this case, you must tell me that. And you must tell me that with specificity so that I can understand exactly what I'm supposed to be looking at, and then I will consider that. So that's my first point that I'd like to bring up. The second is that the Deschutes County Code that applies to appeals of land use decisions, and that is what we're doing here today, states that an appeal statement must raise, and I am now quoting, any issue relied upon for appeal with sufficient specificity to afford the hearings body an adequate opportunity to respond to and resolve each issue in dispute. Let me rephrase section 2232.0208. That's the section I just quoted from. And in the context of my obligation to consider only relevant criterion rules, the applicant, or excuse me, the appellant in this case, or appellants, I should say, in this case, Ron and Rachel Thompson, must clearly set forth evidence or arguments related to relevant approval criteria that demonstrate, in essence, that the staff was wrong in their decision. As noted, I reviewed the staff decision and I reviewed the appeal statement fairly carefully. Haven't made a decision about anything yet, but I reviewed them. But based on that review, I'm having difficulty in identifying the specific issue or issues raised by the appellant where the staff decision is wrong. In other words, how the staff did not apply the relevant approval criteria correctly. Staff referenced in its decision code section 1804030, and it's on page 2 or 3 of the staff decision, as a relevant section to this case. And I believe that section requires an applicant, in this case, to show 3 things. That the proposed lot's 5,000 square feet, that the proposed lot is 50 feet wide, and the proposed lot of record was created in a specific way. From what I looked at in the staff decision, staff is stating that the lot was created by a deed, all right? So I want you to be aware of that. Based on my discussion of the record above and the relevant approval criteria, I asked that the appellant do one or more of the following things. Provide me with a clear and specific statement of the issues as they relate to relevant approval criteria. Secondly, and this is an and/or kind of thing, so you can do all of these. Provide, if the appellant believes that the criteria that are set forth in the staff decision should be added to or should be different than what are set forth in the staff report, then I'm going to ask that the appellant tell me what those criteria are and how they apply to this case. And the final choice, and so you can pick 1, 2, or 3, or maybe more than one, if the appellant believes the staff decision correctly identified the relevant approval criteria, then the appellant must provide evidence and or argument related to those approval criteria that support appellant's appeal. As just noted, or earlier, I serve as a Deschutes County hearings officer and have been assigned to this particular case. In that role, it's my job to be a neutral decision maker. Thus, while I may have a contract with the county to serve in this role, I am obligated, and take that obligation really seriously, I am obligated to remain impartial, and I do not represent the county's interests or the interests of anyone else associated with this case. To that end, I will state for the record that I do not have any relationship with the applicant or appellant, or other than staff who tells me when I'm supposed to be where I'm supposed to be. I am not aware of any connections that I have with any other participants in this proceeding that would prevent me from remaining impartial or neutral. I do not have any ex parte, in other words, outside this hearing, communications with anyone other than staff, and the staff simply sends me information about setting up the hearing and sends me information about what is in the public record. So before we begin, does anyone, either online or in person, does anyone wish to challenge my ability to impartially hear this matter or to challenge the county's jurisdiction in this matter. Ms. Stewart, if you could help me out on this, is anyone raising their hands either online or in person wishing to challenge my ability to hear this case?
Hearings Officer Frank, we don't have anyone in person raising their hands, and then we don't have any Zoom participants hearing.
Thank you. With that, then I am going to continue to hear this case. I will issue my decision in this case based solely on the evidence in the record and the relevant laws or rules that apply to this case. With that, then, it is time and place for staff's presentation. Ms. Stewart, if you wish to do the staff presentation, this would be the time and the place.
Thank you, Hearings Officer. I'll now provide some background on the subject application. Today's hearing is regarding a lot of record verification for property located at 50630 Maston Road to the southwest of Lapine. The property is approximately 24.8 acres in size and adjacent to the Little Deschutes River. The property is predominantly zoned floodplain and a small portion is zoned exclusive farm use. I want to note that this is a continued hearing and the original hearing date was set for April 10th. The hearing was continued at the applicant's request and no oral testimony was taken at the April 10th hearing. The applicant requested a determination on whether the subject property met the definition of a lot of record per 1804-030 of Deschutes County Code. Staff reviewed the application materials and the relevant deed history and determined the subject property was lawfully established. The property appears to have been created through a warranty deed dated October 14th, 1971. Finally, staff notes that a lot of record verification is not subject to the 150-day land use clock. A staff decision approving the application was mailed on January 24th, 2025, and a timely appeal was filed on February 5th, 2025. Issues raised in the appeal materials include the validity of the deed history, whether tax lots 1702 and 1707 constitute a single legal lot, and whether the creation of the subject property complied with PL2. As a more general note, this lot of record verification only confirms whether the subject property is lawfully established. This application does not confirm development potential of the subject property, and any further uses or structures would be subject to separate land use review. And with that, staff is available for any questions from the hearings officer.
I have no questions at this time. Thank you, Ms. Stewart. This will be the time and the place. If the applicant is present, to come forward or get online and give me your testimony, please. Identify yourself for the record, first, last name, and your address.
Thank you. Hopefully everyone can hear me. Lisa Andrak, attorney with Fitch and Neary in Redmond at 210 Southwest 5th Street, Suite 2. And I'm representing Barbara Hanna in this matter. She's currently the owner of the subject property. I agree with the analysis and the assessment of the applicable code criteria addressing a lot of record that's applicable in this case. The criteria that were applied by staff were the lot of record criteria outlining that there are particularly 3 things that an applicant needs to show. The lot is in fact in excess of the 5,000 square feet and has the adequate width that is required by the code. And so the third prong was this lot lawfully established? And that comes from a lot of case law and other directives that have come down through the courts and the legislature. So applying those criteria, we look at when was the alleged creation date for this lot that would predate the current county code, which would regulate creating new lots. In this case, the property was part of some land conveyances that happened over time. And at one point, it was separately conveyed as a single lot in the deed referenced by staff, which was dated October 14th, 1971, recorded in the Deschutes County Real Property Records at Lot and Book, page 200-699. That deed conveyed the single property and predates the county code. So at the time of that conveyance, there was no restriction or prohibition on conveying property or creating a property by deed, and it was pretty common practice prior to land use code regulations that set forth the regulations we currently see, where you have to go through a land use process and get approval from the county or local government in order to create a new lot. Prior to any legislation or local regulations, people created property by deed. And that was the case for this parcel, where the property was identified and outlined and described in a deed, and a conveyance happened. And this was in 1971, before any adoption of the local county code requiring a land use process to create the parcel. So we know that at least prior to any adoption of county code, as set forth in the staff decision, which goes through the detailed history of the county code and the adopted regulations and when the laws changed to require a process in order to create a new parcel. So this property was established in its current configuration at least by 1971, and likely prior there too. But we know that it was created and established in its current configuration before the county's regulations requiring a land use process to create the parcel. So the question before the county was, can you confirm that this parcel was lawfully created and continues to be a legal lot of record? And the deed that we submitted into the record shows that the property was lawfully created by and is described in a deed prior to county code, and it has not changed in its configuration, shape, size, or anything else since then. There were a number of tax assessor role changes that happened that involved this property over the years. A role change is not a method recognized in state or county law to create or change a property. A role change was merely, in this case, was merely the consolidation of a tax lot. And a tax lot is not the same as a legal lot of record. A tax lot can include some or all of various other properties, and that's only designed and described and drawn in a way such that the property owner prefers for tax assessment purposes. Sometimes it includes other parcels, so that as maybe a farm management plan, it can have multiple parcels in a single tax lot. But when you break it up and look at the actual legal lots of record that create that tax lot, there could be a number of legal lots in one single tax lot. So a tax lot is not the same as a legal lot of record. It's just for tax assessment purposes and county record management in some cases. So in this case, the owner of the property had asked the county to combine on a role change for tax assessment purposes the property with another lot, which is contiguous to it, so that he could manage the farm operations that he had for the property. And that role change is relevant, it's in the record, and it did not change the boundary, the legal description, or the legal establishment of this parcel. Further, state law also requires that you go through a land use process to change a lot, to either change its boundaries or to consolidate with a new parcel or to create new parcels from that one. And when that role change happened, that's in the record, which was in 1993, there were already a number of laws in place that would have required a certain land use process to be gone through in order to even consolidate those two lots that were subject to the role change. So just like you need to go through a land use process to divide parcels, you have to go through a land use process to consolidate parcels. So in this case, the process was never done. There was never any deed entered into the real property records to consolidate the legal descriptions of these into a single lot. And there were two owners of the property at the time, and the participant that would have been required for any kind of consolidation application would have been the applicant herein, Barbara Hanna, and who was not part of the conversations with the county about consolidating the parcels for purposes of tax assessment. So there are a number of factors missing in order to argue that these lots were somehow consolidated in 1993, when the roll change was done by the county for purposes of tax lot formation. So the legal lot, the status of the lot as it was created in 1971, continues to be the same configuration of that lot today. And the other parcel has also been considered independently to be its own legal lot of record. And and that's a final determination by the county, which concluded that the other parcel had not changed and its configuration had not been modified or consolidated with the lot that's at issue here today. So with that, I just submit, I think the staff report was correct. It applied all of the applicable criteria to the application, correctly analyzed that applicable criteria, and reached the correct result. And we ask that you affirm that decision.
Thank you, Ms. Sundrick. Appreciate your testimony. I don't have any questions at this time.
Thank you.
Is there any testimony to be offered in support of the applicant's position?
No, hearings officer. We have one person signed up to testify, and that's the appellant.
Okay.
Oh, sorry. Actually, we do have one member of the family who owns the properties would like to testify in support.
Okay. If they'll come forward or raise their hand and get online, wherever they are, you're welcome to testify.
So darn stiff.
It's okay. Take your time.
Thank you for letting me speak. My name is Barbara Hanna, 939 Northwest Cedar Avenue, Redmond, Oregon. I would like to tell you that I knew absolutely nothing about the two lots being converted to one lot, and it came as a shock to me because I had been paying my taxes on two lots instead of one. Nothing was ever said or done about that. And I would like to have two lots instead of just one. Like I said, I knew nothing about this, and so that's why I'm here to correct a mistake that was made a long, long time ago. Thank you.
Thank you, Ms. Hanna. I appreciate your testimony. Anyone else wishing to testify in support?
Thanks.
It sounds like the applicant's team wants to provide some additional testimony.
Okay.
Thank you, Your Honor. I just wanted to follow up on her comments. The consolidation she's referencing is the tax lot consolidation that happened,
Hold up,
which
hold-
is,
Hold up. Just
can you hear me?
I can certainly hear you, but I want to make
Okay.
sure the record identifies you by name.
Okay, Lisa Andrak again for the applicant. The consolidation referenced by Ms. Barbara Hanna is the reference to the tax lot assessor's consolidation of those two lots. I don't think she was part of that process when her husband had asked the county to consolidate those, and she had no idea that that had happened. Again, it doesn't affect the legal record status of this parcel. It was really just for tax assessment purposes. She had only recently found out about that change and was confused about what that meant. So I think that's what her testimony was addressing. So I just wanted to clarify, she's not saying the lots were legally consolidated, only for tax assessment purposes. Thank you.
Thank you. Anyone else wishing to testify in support of the applicant?
Hearings officer, no one else in the room is raising their hand.
Okay, this is a time and a place for the opposition, and I'm going to just slash that and say this is a time and a place for the appellant to testify. If appellant or appellants wish to testify, Ms. Stewart.
Thank you, hearings officer. We have one person here, Ron Thompson, has signed up to testify.
Cool, excellent. Is he in the audience?
He is in person.
All right.
And Mr.
Let's-
Thompson, you can come up to the table here and begin your testimony.
My name is Ron Thompson, Ronald R. Thompson. I have a lot of personal knowledge to do with all of this property. It was originally one lot of about 120 acres.
Mr. Thompson,
That was
hold up. Wait, can we get your address, please?
sure. P.O. Box 3013, Lapine, Oregon. Physical address is 50910 Maston Road, Lapine, Oregon 97739.
Excellent. Go ahead now. Thanks.
So this property has basically been, I own property, my wife and I own property directly across the river from this area. And this role change was enacted or requested by my uncle because he had moved up to Othello, Washington. And so this 120 acres was divided into, I believe, 8 parcels of land, of which these parcels, all these 71 deeded parcels, are a result of that role change. So it was my understanding. I spent a lot of time in the tax assessor's office for them trying to figure out how this all took place themselves. Between this one lot, the Barbara Hanna's property being one lot and 2 lots, and how all that transpired. I totally believe what she said. However, so we have this lot that in question here, and whether it was legally created, and so was it created by deed? I mean, it was a deed, but it had to be a role change prior to being a deed. And there's been a little bit of back and forth here that's been confusing about which role change, the role change that separated the 120 acres into lots, and then another role change that apparently put 2 of the lots back together as one, or not. I'm a little confused on that. At any rate, the lot in question here does not have any access to it, which seems like it should be. There's a lot of things that I'm going to try my best to stick to these 3 criteria, but it's a more of a thing than that. And to do, I guess my concerns with this that really make me feel that things have to be scrutinized very critically is that Attorney Lisa Andrach has been involved in a number of things here, including the falsification of a property deed right across the river from this property, which is excuse me, I'm speaking. It has not. So the point is,
Mr. Thompson,
there is a reason to apply a very heightened degree of analysis and critical activity to all of this.
Mr. Thompson,
It's a property that I have an ownership interest in by way of my easement. And so there's a lot of crooked
Mr. Thompson,
business that's gone on.
I'm gonna
So
Mr. Thompson, you're
to
gonna
get back
have-
to this question of has this
Mr.
lot
Thompson,
been created?
I'm not
properly?
going to allow you to consider.
I can't really say for sure, and I can't hear you.
Okay, then you're
Mr.
going to have to
Thompson, I'm
stop
gonna raise
talking.
the
I'm
volume
not
for a
trying
minute
to
for
be
the hearings
respectful.
Okay.
Mr. Thompson, I really need you to concentrate on the 3 things. And if we're talking about other unrelated matters, then it's not helpful for me. I have to determine, is it 5,000 square feet? Is it 50 feet wide? And when it was first created as a lot, prior to zoning and subdivision and partition laws, when did that happen? And those kind of things can be helpful. What's happened after 1971, if the staff and applicant are correct, is not particularly helpful to me. So
I understand that, and I'm trying to stick to that, but a lot of other things have been said here that bring in a lot of innuendo and other things to do with this, and they are all indication of further issues down the road. The issue of a lot of record is the first step in something else that's coming that we don't know what, but I'm very skeptical about that. So obviously, it's over 5,000 square feet. Obviously, it's over 50 feet wide. Was it created in 1971? That's the question, because my understanding is that it was created all as one lot in 1971 with what's now another lot. So I guess that is for you to decide, and I'm happy to just leave it right there.
Okay, I would ask that you don't leave it right there, because I have a question for you, okay?
Okay.
Because that's what I'm supposed to do, is determine whether or not it was created in 1971 as a single lot. That's really important to me. So I respect where you're coming from. What deed then, if we're talking about deeds, what deed should I be looking at that was 1971 or was the deed of creation? I'm not worried about the 1993 stuff because I know the law well enough that simply separating tax rolls does not create it does not go through the land use process, and that is not when it was created. That part I'm pretty comfortable with. What I am uncomfortable with is when you say that there was a deed that created this lot in a different way. I need to know which deed I'm supposed to look at, because you said I'm going to leave it up to you. I don't know what to look at.
Oh, okay. Well, this all involved my immediate family. And so when my aunt and uncle divided this property up and created these lots was in 1971. All of the lots there have original deeds of 1971, except for one lot across the river from there and adjacent to me and my wife, which didn't have a deed until 1988. But the subject property, it was deeded. It was original deed. It was granted in 1971, and most of them were in October of varying dates that were picked for a reason. So that would be the deed that would have established that piece of land as a legal lot.
Mr. Thompson, let me just ask you a question then. You
Sure.
say that the subject lot was created in 1971 by your uncle. Is that correct?
Yes, by my my aunt and uncle through a deeding it to Robert Hanna and his wife Barbara Hanna, who's here.
And is that the same deed as Miss Andrek and Miss Stewart are referring to?
I don't believe it is. No.
Okay, so what deed was it? Can you point to me the specific deed that we're talking about?
Well, there was only one deed generated in 1971, I believe October 14th, from Clarence and Lila Parsons to Robert and Barbara Hanna.
And that is a separate deed from the deed that Miss Andrek is talking about?
I believe so.
Okay.
Yes.
So do you have a copy or do you have any evidence of the deed that you're talking about?
Let's see. I know I've seen it, whether it's here with me, it probably is. So there was one to my parents, one to Robert Reed and Donna Reed, and this one to the Hannas. I apologize. I assumed that all of these deeds were readily available. They're in the file already.
Well, there's lots of stuff in the file. What I'm asking you is to point to me so I can look at it directly, that deed that you're talking about.
Okay. Again, I'm not sure why all these other deeds here. I'm not sure why our deed was part of this. And that was one of the questions that we had. If I don't come up with that deed, I certainly can provide it, Your Officer.
Yeah, one of the things that I didn't mention in this is that any person who testifies has a right to request the record remain open. And if you don't have that specific document and you want to submit it into the record, I need you to request the record to remain open. I'm not asking you to do that, but I'm just telling you, you have every legal right to do that.
Thank you. I'll just take a minute here and look through this. There are a bunch of different things in here. I didn't actually expect to be here in person. So I had this all home warranty deed. So there were obviously a number of deed changes as things transpired between Barbara Hanna and her husband, Robert Hanna. Okay, it does not appear that I have this in this folder that my wife handed me, but I would request that the record be kept open until we can get that in. Would be very soon.
Okay, so noted.
Any further questions?
Nope.
Okay, thank
I
you very
don't.
much.
I appreciate your testimony. I appreciate your candor. Sounds like an emotional issue for you. I appreciate that as well. But remember what my decision's going to be made about. It's going to be, if this is a deed, and it in fact is the deed that's referenced by Ms. Undrich, then it meets all three of the criteria, and therefore the staff would be correct. Do you understand that?
Are you asking me?
Yep, you're the only
Yes.
person I'm talking to.
Everybody.
You're important to me right now.
Yeah. Okay, thank you.
Okay, that's all I have. Thank you. And is Ms. Stewart, anyone else wishing to testify in opposition or for the appellant?
No one else has signed up to testify, hearings officer.
Okay, then I'm going to ask, is there anybody here who is neutral, which doesn't happen very often, but is there anyone neutral?
There's no one else
All
in
right.
person.
The applicant's now given an opportunity for rebuttal. Ms. Undrich, I'm assuming you'll want to testify.
Yes, thank you. Lisa Andrak again for the applicant. So again, just to reiterate for the record, and maybe the benefit of those in the room, a lot, to be a legal lot of record or to have been created by a deed does not have to first be created by a roll change done by the tax assessor. That is not a requirement to then create later a legal lot subject to the applicable rules in the law at the time. So in this case, it is irrelevant whether or not this lot was first created as a roll change by the tax assessor and then later as a deed. The only thing that is relevant are the applicable laws and criteria as set forth in the staff report. And just as a roll change cannot create new parcels, it cannot consolidate parcels either. So the only way to do so, since we've had a land use process developed in state and local law, is to go through the legal process. In this case, there was never any legal process followed after the 1971 deed that would have somehow changed or consolidated this parcel with another. and rendered the legal lot of record that was described in the October 14th, 1971 deed no longer valid. So, in summary, this deed, the October 17th or October 14th, 1971 deed that I previously referenced, recorded in the Deschutes County Real Property Records at volume 200, page 699, which is from Clarence Parsons and Leela F. Parsons as husband and wife, as grantors, to Robert K. Hanna and Barbara J. Hanna as husband and wife, and as described therein. That is still the current description of the parcel that's at issue today. So I believe staff had that decision correct. They applied the analysis and the criteria correctly, and it is consistent with state law and the county law. And I'm not going to respond to the other comments that Mr. Thomas made. I don't think it's relevant.
Okay, and as I asked Mr. Thompson, at this point in time, I'm not aware, but I'm asking if there's something I'm not aware of to be pointed out to me. If there is a deed that is not the deed that you're talking about on October 14th, 1971. So if you're aware of that, great, let me know. If you're unaware of that, great, let me know.
I have no knowledge of any other deed executed on the exact same day by the same parties. Further, I also would say for the record that if that deed did exist, it would have lawfully created a parcel, but we don't have any other information about that deed and that parcel. The only thing that we've ever found in the records for the real property and the county records pertaining to this property are consistent with what is already in the record describing the parcel before you today, and which was also described in the deed from 1971.
And to clarify, the parcel described today is the single lot that we're talking about.
That's correct.
Okay.
There were no other lots described in that same deed. And even if there had been, just for the record, it would not have effectively consolidated those parcels. That's already clearly established at state law.
I understand. Thank you.
Thank you.
I don't have any additional questions.
Okay, thank you. And I was going to ask to close the record. I know you'll make that determination, but we don't have anything else to provide. Thank
Okay.
you.
And lawfully, I'm required, if requested, to keep the record open, so I appreciate your comment. Ms. Stewart.
Thank you, hearings officer. My only closing comment is I will double check whether the tax card for the parent parcel, which was tax lot number 1700, is in the record. I believe it is, but if it's not, I'll upload that to the record if there is an open record period, just to help the hearings officer with your
Okay.
analysis, looking through the deed history.
Excellent. Okay, you want to talk to me a little bit about the open record period? My proposal is to keep the record open. Yeah, thank you. Always ahead of me. So if you want to describe that to the audience and those participants and anyone else who listens to it or sees this later, what you're talking about on this screenshot, and then I'll close the hearing.
Thank you, hearings officer. So if there is going to be a standard 777 open record period, these are the deadlines that apply. So everyone has until 4 p.m. next Friday, September 19th, to submit new evidence and testimony. And then anyone can submit rebuttal testimony until 4 p.m. on Friday, September 26th. And this rebuttal needs to be directed at evidence and arguments that are already in the record. And then the applicant, if they so choose, will have up until 4 p.m. on Friday, October 3rd to submit their final legal argument. Some additional notes about the open record period is please send all submittals to me. Electronic submittals should be sent to audrey.stewart@deschutes.org. Deschutes County does not take responsibility for retrieving information from a website link or a personal cloud storage device. And electronic submittals must be received by the county server by 4 p.m. on the date of the deadline, so please do not wait until the last minute. And with that, I'll turn it back over to the hearings officer.
Okay, thank you. So I just want to reiterate a couple things that Ms. Stewart raised. It is your responsibility to get things in on time. Those times are 4 p.m. on the 19th for new evidence. It's 4 p.m. on the 26th of September for rebuttal evidence, and 4 p.m. just for the applicant only. So, Mr. Thompson, after the 26th, you can't submit anything, just to let you know. But the applicant has the right of final rebuttal under state law until 4 p.m. on the 3rd. So it is your responsibility. If we were in class, the teacher does not accept late homework, does not accept late submittals. And if you do in fact submit something late, it will not be part of my consideration. My suggestion is always to get whatever you want into the record at least one full day before the deadline. That assures you that it's in fact is part of the record. And I also tell you that if you're uncertain as to whether or not your information did in fact get received by Ms. Stewart at the county, you feel free to contact the county and confirm that your evidence has been received. That's good practice. That's good habit. That assures you that whatever you took the time and effort to submit actually gets put into the record. So with that, then the record will remain open until the 19th for new evidence, 26th for rebuttal evidence, and applicant's final rebuttal, in fact, is the 3rd. Just a comment to Ms. Endrick, just to let you know that anytime after 4 p.m., in my opinion, but preferably sometime the next Monday, you may submit a request to close the record early, since you're the only one who has the right, and I will consider that request when starting what I believe is my 21 days to get the decision out. So if you'd like to save a little time, you can certainly save a portion of that last week by saying, I don't have any final argument, or you can submit your final argument early if you'd like, which is always appreciated. So with that, then, I appreciate the courtesy. I appreciate the respect shown in this hearing. As always, I appreciate staff's participation in these hearings. I will issue a written decision. The decision includes a right of appeal, and it will be explained briefly in the decision. But if in fact you do decide to disagree with my decision, contact Ms. Stewart and talk about your options there. She's not going to give you legal advice, but she certainly can tell you what the options are under the code. So with that, we'll close the public hearing. Thank you so much for coming. I will issue my decision shortly. Thank you. Hearing's closed.